Okay, so on to Article 2 out of 7. Um, they get shorter as they go on. Article 2 of the Constitution of the United States of America establishes the executive branch. So, Article 2, Section 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President chosen for the same term, be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. The electors shall meet in their respective states and vote by ballot for two persons, of whom one at least shall not be an inhabitant of the same state with themselves, and they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and House of Representatives, open all the certificates, and the votes shall be then counted. The person having the greatest number of votes shall be the president, if such number be a majority of the whole number of electors appointed, and if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president, and if no person have a majority, then from the five highest on the list, the said House shall in like manner choose the president. But in choosing the president, the vote shall be taken by states in representation from each state having one vote. A quorum for this purpose shall consist of a member of or members from two-thirds of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the president, the person having the greatest number of votes of the electors shall be the vice president. But if there should remain two or more who have equal votes, the Senate shall choose from them by ballot the vice president. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President, neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States. In case of the removal of the President from office or his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice President, and the Congress may, by law, provide for the case of removal, death, resignation, or inability both of the President and Vice President, declaring what officer shall then act as President, and such officer shall act accordingly until the disability be removed or a President shall be elected. The President shall, at stated times, receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. Before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will to the best of my ability preserve and protect and defend the Constitution of the United States. Okay, so the United States differs from most democratic countries in which presidents are typically elected by popular vote. The United States uses a system called the Electoral College, in which 538 electors are taken from the states and the District of Columbia to represent the population. This is a complicated system that had electors previously being chosen by the state legislatures and was similar to the Senate in that it had public opinions being sent through a deliberative intermediate institution. The Electoral College has had significant controversy surrounding its function and format and has been changed numerous times. In modern day, it is not considered to deliberate on public opinion and systematically awards votes to winners as designated by public elections. Awards votes to winners as designated by public elections. Electors do have the ability to not represent their districts and to vote for whomever they choose. In the early times of the Constitution, electors would cast ballots for two presidential candidates, and whoever received the second most votes would become vice president. This led to a presidential electoral crisis early in the nation's history and made it apparent that the system should be altered. It was often the case when the president and vice president represented different political parties, for example. There was often the case. Okay, so the 12th Amendment did much to change the possibility of ties and differing political views affecting the presidency and vice presidency. However, the Electoral College does remain intact and continues to affect presidential elections in ways that do not exist outside of the United States. It is outlined in Article 2 that states are given a specified number of electors that is equal to their delegation to Congress. The electors are given their titles based upon procedures set in each state's legislature. Nearly all states, excepting two, award their electoral votes in a winner-take-all method, meaning Nebraska award electors based upon congressional district, in addition to some electoral votes based on the state's total winner. Throughout the United States history, there have been multiple instances of different state methodologies in awarding electoral votes, some even circumventing a popular election altogether. Others have used popular vote to elect the electors in various forms of election procedures. The Supreme Court has upheld that the appointment and mode of appointment of electors belong exclusively to the states under the Constitution of the United States. Therefore, state legislatures do not have to conform to public will in the establishment of electors. The Supreme Court has gone so far as to state that individual citizen has no federal constitutional right to vote for electors for the President of the United States. The most significant controversy regarding the Electoral College is its knack for allowing the popular vote to differ from the results of the electors themselves. As a result of the Electoral College, there's a likelihood that so-called swing states are the sole targets of presidential campaigning, as they ultimately decide most election outcomes. Those who show support for the Electoral College often argue that it preserves a sense of federalism regarding presidential elections and implements nationwide support for the president. There is a modern idea that is coming into fruition, which involves blocks of states agreeing to give electoral votes to the national popular vote winner rather than the individual state winner. Since there is a large disagreement over the purpose of the Electoral College, it is likely that such an idea will take shape and receive public support. Article 2, Section 1 states, the executive power shall be vested in a President of the United States. This establishes an office for an executive to occupy. However, during the founding, establishing such an executive was not a discernible goal. There was no executive in the Articles of Confederation. Such responsibilities that we consider related to an executive office were undertaken by congressional committees and by boards and/or secretaries, which were directed by the Congress. It was also not obvious that a single person would head the executive. Some of the states at the time had numerous executives that formed a committee-like structure that some at the Philadelphia Convention supported such a plural executive. Many agree that this vesting clause creates a unitary executive such that it makes a single president. Established individuals with knowledge relating to the constitutional history, have belittled the clause in a sense that they disagree with others who argue that the clause gives the president all of the executive power. Those who argue in favor of the president having the executive power call this having a unitary executive. This argument could be considered folly, however, since it is common knowledge that the Constitution does, in fact, create a unitary executive. Minimalists argue contrary to a unitary executive in that they believe in the least ambitious interpretation of presidential authority. However, there are two primary disagreements. Firstly is the term executive power, a group of powers that go further than the scope outlined in the Constitution. Many disagree on whether the Founding Fathers had a particular meaning when referring to the executive power of the United States. Some would say that there is such a unitary executive position, including a group of powers to be used in executing the law, conducting foreign affairs, making war, etc. There are, without question, limits on executive power present in the Constitution, but a far-reaching presidential power is included in a unitary executive formulation. Secondly, in the vesting of powers in a single executive, whether the vesting clause creates a presidential position that has absolute authority and directly supervising and dismissing federal officials is debated. Those who argue for a unitary executive often include the argument that Congress cannot interfere with his or her constitutional exercise of power in the oversight of officers of the executive branch. Minimalists, though, of the vesting clause will claim that Congress, with its legislative powers, and including the necessary and proper clause, can interfere with the president's exercise of power where the Constitution does not exclusively designate discretion. These complexities are important, or these paradoxes, conundrums, directly the differing perspectives of the vesting clause, both the unitary and minimalist, are expressly viewed as varied. If it were that the unitary executive position were made prominent, it is possible that all federal government independent agencies could be considered unconstitutional as a result of restrictions by Congress on the president's power to remove federal government members. Summarily, these preventions would be viewed as unnecessarily infringing the president's supervision and control. If the minimalist position were to prevail, there is no prevention of Congress from removing anyone in the whole bureaucracy, including important officials, an example being the Secretary of State. It is important and consequential that the president has the ability to faithfully execute laws, and if he or she did not have full authority to do so, Congress would be able to severely change the relationship between the president and the departments of the executive. The doctrine emanating from the judiciary regarding these issues is convoluted. From the court's perspective, the powers vested in the president are independent of the rest of Article 2. The court has at times both allowed the president to dismiss a federal official as well as assign a federal official without a congressional approval. He or she, the president, also exhausts the extremity of foreign affairs abilities. However, Congress has been allowed the ability to exempt public officials from the reach of executive authority. They have limited the president's ability to remove a commissioner in one instance, though the president has still been able to remove independent prosecutors in other instances. The court has particularly avoided answering questions surrounding the vesting clause. Vesting clause issues come to light regularly when the government uses its power contrary to current understandings of the separation of powers. A couple of questions in the example are whether the president may dissolve a treaty unilaterally or settle disputes in the international realm by negotiation before submission to Congress, therefore working around the treaty clause. It is in high probability that the various branches of the government will come to a provisional understanding of the arguments rather than elicit a contextually clear resolve from the Supreme Court. This is a result of statutorily created provisions being made through court cases with similar outcomes, and also a result of issues regarding the separation of powers being heavily involved with historical practice. Arguably, the most natural interpretation of the vesting clause is that the presidency is that the president is in essence unitary and powerful in the laws of the United States being executed. It is possible to read the text more narrowly by interpreting it as the presidency being held by one person. However, these two instances are practically one and the same. The Constitution defines part of the presidential duty as to take care that the laws be faithfully executed in a later section of Article 2, and therefore the overreaching presidential duty would imply that the president has the ability to do what is necessary to accomplish such. The argument to be made here is that the president has the power, in a natural understanding of the text, to execute the laws unitarily as well as was understood by the Founding Fathers. However, understanding the vesting clause more broadly and therefore incorporating residual powers, perhaps by bypassing Congress, etc., would undoubtedly change the separation of powers outlined in the Constitution, and it would do damage to the Founding Fathers' intended intentions. Under the Articles of Confederation, there was widespread dissatisfaction with a legislatively dominant federal government and a large interest in a powerful executive. The revulsion of a monarchical system did follow into a disposition against such an executive having unenumerated powers. One Supreme Court justice described the president's power as being weakest at times when they are exclusively used and avoidant of the legislature, mimicking the Founding Fathers' intentions. Those in favor of the Constitution arrived at the idea that a government of enumerated powers did well to complement one that set ambition against ambition. What could be understood as a natural reading of the constitutional text is undermined by the debates of the various ratification conventions. A common critique of the Constitution was that it gave the president monarchical powers and would lead to a repression back to that form of government. Although many who shared these concerns were quick to find issue with the Constitution, they failed in identifying unstated or residual powers. Also, defenders of the Constitution never demonstrated or defined such residual powers as being allowable, though they did express the powers enumerated to be allowed and failed to exemplify the unfortunate consequences. In summary, none of the Founding Fathers expressed unintentional consequences or implications of the president having executive power, and there was no grand meaning shadowing the vesting clause. It wasn't until, albeit quickly, after the ratification of the Constitution that voices began to discern possible grander meanings of the vesting clause. Some consequences have come to light more recently, especially of an extremely strong, wide-ranging understanding of the vesting clause, such as deciding not to spend funds allocated by Congress and the ability to limit publicly certain communications emanating from the president. There have been multiple attempts, sometimes successful, to disobey congressional acts where the intentions were to compel certain actions of the executive branch. It can be plainly seen that expanding the interpretation of the vesting clause to include unspecified extreme executive power would implicate the checks and balances system outlined in the Constitution. In general, the Supreme Court has interpreted the vesting clause in light of a natural reading, and in doing so defended the defined structure, historical, and political context of the Constitution. The limited enumerations of powers specified by Article 2 would convince one that the president's position was one of limited authority. An example of limited ability by the president is the Senate having extreme implications regarding the negotiation of treaties and more. Despite him or her being responsible for faithfully executing the laws, an individual might interpret the Constitution as giving no authority at all to do so. The president of today could be viewed as vastly different from that outlined in the constitutional text. However, from the creation of the Constitution, presidential powers have been, without a doubt, significant. The first president's forward enthralled a position with vast power, including the execution of laws, foreign affairs, and appointments to office. There is no statute that outlines authority to convey these actions except the Constitution itself when it gives the executive power of the United States to the President. At the time of the founding, the principle of executive power was familiar, since many state constitutions gave similar authority through provisions that granted similar powers. A near copy of such contextual authority is found in the Constitution. The general structural grant of power to the President was not uncommon. In regard to an executive chief, through the vesting clause, there are two important departures from true presidential power. Firstly, the clause does not grant the same powers as it does to Congress, which means the president is unable to pursue endeavors that are related to war declaration or foreign commerce regulation. Secondly, there exist certain constitutional checks that rein in the authority of the executive. For example, the president is unable to make appointments or establish treaties unless consented to and advised by the Senate. There are reasonable arguments made by minimalists for limited executive power, though they disregard the historical implications and proceedings regarding the text. There are assertions by past 1700s and understandings of executive power, which had meaning at that time. It explained the ability to implement similar powers as are in the contemporary meaning. Also, interpretation leads us to compare the differences deciphered in Articles 1 through 3, all of which vest power, whether legislative, executive, or judicial, into a body of authority, and in summary, minimalists would have others understand the vesting clause as not instituting any powers at all. Okay, so the Supreme Court on occasion has interpreted the vesting clause as granting powers further than those enumerated in Article 2. Numerous cases have cited the clause personally to remove supervisory powers over executive officers, and as a source of three powers: law enforcement, foreign affairs, and again, the supervisory power over the executive branch. The Supreme Court has even repeatedly given heed to the President's ability to remove commissioners and the other executive officers resulting from the vesting clause. Many Supreme Court cases have also implemented limits on the extremity of executive power and its spreading. They have prevented the implementation of a so-called fourth branch of government with shared executive, judicial, and legislative authority. While the clause grants the President substantive powers not found elsewhere in the Constitution, Congress may regulate to some uncertain extent the exercise of those powers. One of the most prominent instances of distancing from the Articles of Confederation was the creation of the office of the presidency under the Constitution. Several clauses under Article 2 outline the methodology and design of the executive branch and include the system for selecting the president, eligibility for the executive position, money paid to the position, and the office's oath. The Electoral College was created in Article 2, Section 1, and remains intact today. However, it is considerably different than when it was initially adopted. There's much that can be ascertained from studying what the founders intended. Since the process of electing the president was very much important to them, it is typically not conceived in this way, but the Electoral College is the fourth institution created by the Constitution. It is also important to mention that with the creation of political parties, nominations for the president were decided by state laws and primaries through the parties. There were four primary goals regarding the Electoral College. First of these was that the Electoral College was to be a means of support for the president. Secondly, the intention of the founding fathers was to create an institution to legitimize the president. The process of choosing electors and having them vote for leaders was popular at the time of the founding and would represent the public voice. Thirdly, it was believed that having a system like the Electoral College would prevent tyrants and demagogues from being elected president, as discretion would be held by a chosen few. Fourth and final, it was seen that the Electoral College would be more prone to elect leaders based on merit rather than popularity. The eligibility clause of the Constitution outlines the requirements of running for the office of president, and it has two main instances regarding it. Firstly, it was important to establish loyalty with the nation, hence the president must be a natural-born citizen. Secondly, there is a required age of 35 years to become president. This requirement was intended to increase the chance that there would be some experience ascertained before leading the executive branch. The compensation clause present in the Constitution has two primary goals as well. Firstly, there's no set salary by the Constitution, but it does promise compensation for the office to prevent it from only allowing the wealthy the ability to occupy it. Secondly, the compensation is outlined as not to be adjusted while the president is serving. The end of Article 2, Section 1 provides for the presidential oath of office. Although there are other oaths required by the Constitution, only the president's is given word for word in the Constitution. Also, a dedication to the Constitution itself is spelled out in the text. President Lincoln explained that the oath was both a limit on presidential authority as well as an acceptance of presidential discretion. He argued that although he was dedicated to the rules set in the Constitution, it was also his responsibility to stretch the limits of his power in pursuit of what he believed as was righteous. Clause 2 of Article 2, Section 1 begins by stating that electors shall be appointed by the direction of state legislatures. This gives broad discretion to the manner in which the president is elected, albeit still through the lens of the Electoral College. There are numerous variations amongst the electoral processes throughout the states. In modern day, there is a passionate movement called the National Popular Vote, or NPV. This is a multi-state compact that relies on the powers provided to the state legislatures. The members of this group include the legislatures of Maryland, California, Hawaii, Illinois, Massachusetts, New Jersey, New York, Rhode Island, Vermont, Washington, and the District of Columbia. They have said that they will give their electoral college votes to whoever wins the national popular vote for president. This coalition only becomes valid when a number of states whose votes comprise the needed 270 electoral college votes become members. So this grouping for the cause of enacting or electing the winner of the national popular vote would upend the current system in a multitude of ways. Besides the obvious that the winner would be elected by popular vote, it would allow that every vote counts toward the presidency. It would also prioritize other states not typically campaigned in by presidential candidates and prevent some of the mischievous election happenings in so-called swing states that have plagued presidential elections in modern history. Some criticize the national popular vote and argue that the Electoral College is working properly today. One argument against the NPV is that it would be unconstitutional. However, there is no language present in the Constitution that a state-by-state and winner-take-all method be designated for presidential elections. Furthermore, there is no outline for how state legislatures must award the position to their electors, and it varies vastly between states. The Supreme Court has effectively defended states' autonomy in choosing their electors multiple times. The national popular vote has both a sound constitutional basis and a compelling democratic logic. Okay, on to Article 2, Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states. When called into the actual service of the United States, he may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. He shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall nominate, and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper, in the President alone, in the courts of law, or in the heads of departments. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. This clause states the President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. As one Supreme Court justice stated, these cryptic words have given rise to some of the most persistent controversies in our constitutional history. Also, presidents have continued their various arguments to the degree to which they control the military. Minimally, everyone agrees that there are two distinct purposes of the clause which are in themselves related. Firstly, there is an intention of the Founding Fathers to put civil restraints on the military. Secondly, instead of putting civil superintendents above the military into the hands of a Congress or legislature, it is put into a single executive. Congress is prohibited from transferring the power of the military to anyone other than the President. As well, Congress cannot distribute partial military power anywhere other than under the President or interfere with the President's ultimate role. Particularly at one point was Congress in violation of the clause when, after the Civil War, they sought to bypass the President and grant the overall military command to their top general. When Congress does authorize military operations, for example, war declarations, it is required to put the President in charge of them. It supposes without question that the President is not only in charge of military operations, but also in charge of how they are carried out. An even more challenging question arises when analyzing the power of the President beyond operations that were approved by Congress. Such powers include those to defend against attacks on the United States. This power is exonerated by the Commander-in-Chief Clause, which can be read to give substantive independent power to confer military matters besides those initiated by war declaration. Many presidents have established authority over various military acts, including attacking pirates, rescuing U.S. citizens abroad, and making military deployments. However, this authority is presumably circumscribed by other provisions of the Constitution and perhaps some have argued by international law. Some situations have been interpreted to the extent that the authority of the President derived from the Commander-in-Chief Clause does not extend to diminishing the rights of civilians of the United States who are not on the battlefield. The most debated facet of the clause, though, is regarding whether Congress may institute statutes prescribing how military operations are to be carried out. Many presidents have argued that the War Powers Resolution, which limits the president's ability to deploy troops into hostilities without Congress's approval, is in fact unconstitutional. In 2002, a government memorandum stated Congress can no more interfere with the president's conduct of interrogation of enemy combatants than it can dictate strategic or tactical decisions on the battlefield. Just as statutes that order the president to conduct warfare in a certain manner or for specific goals would be unconstitutional, so too are laws that seek to prevent the president from gaining the intelligence he or she believes necessary to prevent attacks upon the United States. This memorandum was extremely controversial. There are further implications of Congress limiting the president's war powers, and Supreme Court cases have remained unclear. To summarize, the Commander-in-Chief Clause gives the president exclusive ability over the military and operations acceptable by Congress. It most likely gives the president independent ability as long as it does not interfere with the sole powers of Congress or other constitutional provisions. It is undecided whether it can put limitations on Congress's ability to make statutes governing the operations of specific military engagements. Mainly, arguments regarding the Commander-in-Chief Clause have failed to address the importance of other constitutional provisions in interpreting the separation of emergency powers in the Constitution. Possibly, the so-called Calling Forth Clause has been the most dismissed. In this regard, the Calling Forth Clause allows for Congress to provide for the calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. One Supreme Court justice stated such a limitation on the command power, written at a time when the militia rather than a standing army was contemplated as a military weapon of the Republic, underscores the Constitution's policy that Congress, not the executive, should control utilization of the war power as an instrument of domestic policy. However, besides how it is related to debates revolving around the Second Amendment and the ability to deploy the National Guard units in foreign lands, the ability of Congress has been discounted in most examinations of the President's powers of war. However, the President has been declared to have, to a degree, independent ability to provide military force during emergencies domestically. They assume that Commander-in-Chief Clause designates this reference power. Congress has provisioned statute-related ability to deploy the military based on the Calling Forth Clause to the President. Some of the war powers in relation to the defense of the United States comes from statutes by Congress under the Calling Forth Clause, similar to those provisions granted by the Commander-in-Chief Clause. An important note to make is that the Calling Forth Clause is no longer a contemporarily examined clause, and cases by the Supreme Court have led to arguments regarding the substantive limitations on the federal government being widely nullified. Justices concluded that the Calling Forth Clause does not in fact limit the circumstances in which the government may call out the militia. Therefore, largely, even the Founding Fathers were intent on the militia being solely responsive to emergencies in the United States. They were allowed to be called to a fight in foreign lands. The Supreme Court has now even gone so far as to consider National Guard members as federal regulars when they are put into active service. It is allowable for them to fight in foreign lands. Summarily, there's no so-called militia in the view of the Supreme Court, and all military members are considered to be regulars. So construed, the Calling Forth Clause undermines the ever more visible arguments in favor of strong and unilateral domestic presidential war powers. This is because if the militia was initially intended to be the primary, if not exclusive, response force for a domestic emergency, and if Congress was given the power to provide for their calling forth and through the other militia clause or regulation, then the Constitution appears to resolve in Congress's favor any arguments that such statutory limitations unconstitutionally infringe upon the President's constitutional authority as Commander-in-Chief. Undermining a spacious and wide-ranging unilateral ability of the President to execute the laws of the Union, suppress insurrections, and repel invasions is given by the intent that Congress has the ability to provision responses by the federal government to remedy extreme crisis in the United States. Whether Congress is responsible or even has a provisional ability to enact statutes or regulations regarding the undertaking of military operations is questionable. It is a desperately argued debate. Many argue that the Commander-in-Chief Clause substantiates grand executive power and full authority for the President to command. An opposing argument views Congress as having the ability to govern, at least somewhat, the President's military operations and leaves the President to only have authority where Congress has not specified orders. Congress has the ability to make rules for the government and regulation of the land and naval forces, and none of the constitutional text refers to the rules as being devoted to presidential intent. Though the President would undoubtedly be able to veto such, Congress has enacted certain codes and regulations regarding how the military is to conduct itself during and not during times of war. Congress does, in fact, have much power over the military. However, despite these facts, Congress can make general rules regarding military conduct and can define wartime objectives, but it lacks enumerated power to direct battlefield operations. The Articles of Confederation, unlike the Constitution, gave Congress the ability to direct such military operations of the land and naval forces, but the modern Constitution differs significantly from the Articles of Confederation and strongly suggests that Congress's government and regulation power does not include power to direct military operations. There was, in fact, a war powers debate at the convention in Philadelphia, and it is common knowledge amongst historians that one founder changed the ability of Congress to make war to the ability to declare it. The intention was to give the president full capability to defend against sudden attacks on the United States. One founder wrote, "The direction of war peculiarly demands those qualities which distinguish the exercise of power by a single hand. The direction of war implies the direction of common strength, and the power of directing and employing the common strength forms a usual and essential part in the definition of executive authority." This quote is in accordance with the pre-constitutional critique, which argued that the federal government had lacked separation of powers under the Articles of Confederation. To summarize, the president is at the mercy of Congress in relation to specified and general rules regarding military upkeep and presentation. All other powers not enumerated to Congress are at the President's discretion, the most significant of which is the ability to direct war operations. It may be challenging to discern the difference between rules set by Congress and the directing of military operations by the President. In general, Congress can maintain that the military be operated in accordance with statutes, but lacks the ability to make significant battlefield determinations. The second paragraph of Article 2, Section 2, states that the President has the power to make treaties with the advice and consent of the Senate, as long as two-thirds of the Senate agree. Therefore, the power to make treaties is shared between the Senate and the President. However, common practice has become to leave the Senate in an agree or disagree type of position, allowing for the imposition of conditions to the treaty. For the purpose of diplomatically communicating, the negotiation of treaties has largely been left to the President, and since the beginning of the government, the Senate has not been explicitly required to confer and advise the President before a treaty's effect. It is also important to note that once the Senate puts conditions or reservations on a treaty, the treaty is null until the President chooses to ratify it. The implication of a president terminating a treaty without Senate agreement is much more controversial. The Supreme Court has held that a treaty cannot be terminated by the President without being in accordance with the wording of the treaty itself. The Supremacy Clause allows for treaties to be the supreme law of the land, and termination would be an overreach of presidential power. There is an issue with the treaty clause in terms of the enumerated powers and separation of powers, but the Supreme Court has imposed treaties as not having the ability to infringe on individual rights presented in the Constitution. A further debated instance is that of the treaty clause being the only method for creating significant pacts with foreign entities. The reality is that most of the agreements the United States has with other nations are not formalized by treaties. The Supreme Court has even gone so far as to allow executive agreements to be maintained by the President, operating unilaterally, if not only in certain situations. The Supreme Court has not detailed the exact extent to which executive agreements are allowed. There are also congressional executive agreements which take place when Congress enacts legislation authorizing agreement with foreign powers. Such trade agreements, such as the North American Free Trade Agreement, were imposed by statute. It can be seen that congressional executive agreements foregoing Senate consent and approval are arguably more appropriate in circumstances that involve the congressional powers revolving around foreign affairs. For example, Congress's ability to regulate commerce with foreign entities. However, these statutes typically do not produce significantly binding agreements that require substantial commitment. Pause. Okay, so further in Article 2, there comes the instance of appointments, and the Constitution allows four differing modes for making appointments. The most common process allows the President to nominate the Senate to consent. Though inferior officers are typically allowed by Congress to be filled by the President acting alone, the Supreme Court has not distinguished significantly the difference between officers requiring consent and those deemed inferior, but has stated that there is not allowed to be incongruity between the functions normally performed by the courts and the performance of their duty to appoint. Any appointee exercising significant authority pursuant to the laws of the United States is considered by the Supreme Court to be an officer of the United States. However, a typical federal employee is not considered an officer if they only perform responsibilities to help functions that Congress has the ability to carry out itself or are substantially removed from the administration and enforcement of law. There has been at least one Supreme Court case that delves into the distinction between officers and typical employees. Furthermore, there is a difference exacted between principal officers and inferior officers. Possibly the largest controversy surrounding the Appointments Clause is its process for removing federal officers. The Supreme Court has stated that Congress cannot give conditions for removal of a federal officer based on advice and consent from the Senate, and may not permit itself any exact role in removing an officer besides through impeachment. These instances do not substantiate whether Congress may put limits on the removal power of the president. The Supreme Court has given credence to restrictions on presidential removal power as long as the limitations do not prevent the constitutionally enumerated processes of the president. This then provides that the president does have at least some power in the removal of all officers. He or she would not be able to maintain laws being faithfully executed. The Supreme Court has also presented the idea that inferior officers must be removable by the heads of departments who appointed them if the heads of departments are not at will removable by the president. There's also a provision in the Constitution, the Recess Appointments Clause. This was enacted with the idea that the government must be operated throughout the year, although Congress would usually be absent for long periods. Regardless, this clause has presented two conundrums: whether the power of recess appointment extends to vacancies that took place when the Senate was not recessed, and whether the recess appointment power applies to adjournments taking place during a Senate session or only between sessions. The Supreme Court has held that the intersession recess in question must be 10 days or longer. Two important institutional relationships are maintained by Article 2 of the Constitution: the relationship between Congress and the President, and the relationship between the executive branch and the President. Throughout the United States history, there have been many debates and arguments over the nature of the presidency, and the Constitution lacks much text defining the exact nature. The relationship between the President and the legislature, though, is largely based on the precedents set by the first President, President Washington. For example, the presentation of treaties to the Senate for consent after the treaty was already established began under the Washington administration. It can therefore be seen that some of the ambiguity of the Constitution was reconciled by the first Congress and President Washington. See him up there. There is less constitutionally based precedent to be had in the relationship the president has with the institutions created by Congress, rather than the federal judiciary, such as all the entities comprising the executive branch. Recently, much credence has been given to the idea of a unitary executive in which the president's power is extended to all portions of the executive branch, and Congress does not have much discretion in its affairs. The Supreme Court at one point held that Congress cannot violate the separation of powers and infringe on the ability of the president to supervise the executive branch. The Executive Power Vesting Clause, the Faithful Execution Clause, and the Written Opinions Clause are perceived to maintain a couple of constitutional mandates. Firstly, the President is able to execute laws and impose any decisions he or she believes correct as it relates to any officer's position within the executive branch. Secondly, the President is able to remove any officer serving within the executive branch. There are problems with these interpretations, however. These clauses did not have the intended purposes imagined by proponents of a unitary executive during the founding. It can be seen in the state governments before the Constitution that the governors, legislatures, and sometimes the court systems all shared in the responsibilities of maintaining executive functions. Arguments for a strong unitary executive, from an originalist point of view, imply that state constitutions only had problems and did not provide examples for remediation in instances of separation of powers. Also, there is no argument for a unitary executive that would come from historical precedent. The first Congress's structuring of the executive departments lacks any implication of a unitary executive function. Some who favor a unitary executive assert a prevalent supervisory role of the president, but, for example, there was nearly no interference from the president in early executive functions, such as the mint or applications for patents. There is simply no credence to the idea that Congress intended to ever give the president power over all officers that have been delegated as part of the executive branch. Rather, it can be seen that none of the president's enumerated powers prevent the limiting of his power over subordinates by Congress. Thus, the relationship between the president and the rest of the executive branch is largely determined by the relationship between the president and Congress. There is an error present when the judicially related practice of the treaty clause and the appointments clause stray from the originalist views of the Constitution. The original meaning of the Constitution is interpreted by the historical and legal context of its writing, and an original interpretation of these two clauses would arguably both favor and disfavor presidential power, but most importantly, they would provide accountability. Also, they would distinguish lines in the rules and prevent the Supreme Court from its typical favoring of itself and its tendency to favor its rulings for opaque balancing acts or tests. It is important for the Appointments Clause to be regarded through the lens of executive power given to the President. The executive authority included traditional powers granted to the President. Unlike enumerated powers, which were granted to Congress, the traditional powers of the executive included some that are given to Congress. The Appointments Clause, for example, gives the Senate power to advise and consent on nominations, and since the Constitution does not alter presidential power to remove officers, That ability is retained by traditional executive authority. This position on traditional executive authority is exemplified by debates held by the First Congress. Disagreeing decisions have been made by the Supreme Court, however, and they are both wrong and unclear. The court allowed that the president's power of removal be based on the stature and scope of the officer in question. Also, the Supreme Court is wrong in allowing judicial appointment of executive officers without incongruity between the functions normally performed by the courts and the performance of their duty to appoint. Since the Appointments Clause is understood in relation to Article 2, the Supreme Court's authority should be understood in relation to Article 3. Although the judicial branch has the power to appoint officers extending to cases, this should be done in a complementary manner rather than an overreaching instance of judicial power. It is also important to define what an inferior officer is and the scope and reach of their authority. An inferior officer must be a subordinate in principle, and hopefully the Supreme Court will embrace this rule. The Supreme Court has also disregarded the original meaning of the Recess Appointments Clause. The ability to make recess appointments should only be exhausted when the Senate vacancies take place while the Senate is not in recess. There should be a distinction between a recess and a state of affairs. The Supreme Court should also delineate the meaning of recess and apply it exclusively to intersession recesses rather than intersession recesses. The Treaty Clause is another instance of the Supreme Court botching the original meaning of the Constitution, similar to the manner in which the President is able to remove officials besides those protected by the Appointments Clause. He or she can also diminish treaties as long as it does not violate the terms of the treaty. The Supreme Court is proper in allowing the President and the Senate the ability to create treaties beyond the enumeration of powers. This is because there is a protection against abuse resulting from supermajority rule. Executive agreement arguably should be permissible, and the circumvention of the Senate supermajority should only occur in limited instances. For example, when they are based solely on independent presidential authority, like the authority to recognize foreign nation states. Congressional executive agreements, however, diminish much of the treaty clause's power. Article 2, Section 3, Article 2, Section 3. He shall from time to time give the Congress information of the State of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses or either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such a time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Like other sections of Article 2, this section both gives and limits the power of the President and gives him or her the ability to call Congress on extraordinary occasions, which has been enacted to gather Congress for an assortment of instances regarding wars, nominations, and emergencies, and although never used, it gives the President the ability to adjourn Congress if they cannot agree to do so on their own. Section 3 of Article 2 creates various responsibilities for the President. The President must give a State of the Union, albeit at his or her convenience. The President must grant reference and information to the legislature, being Congress, and the President shall host foreign diplomats, which is in fact controversial in whether it distributes power to recognize foreign nations and their governments to the President. Also, the President has the duty to authenticate the positionings of federal officials. However, the most important clause of Section 3 is the Faithful Execution Clause, which is also described as the Take Care Clause. This clause is a prime resource in determining the broad enforcement ability of the President. It is also limiting presidential power because it implies that the executive must execute the laws of the legislature faithfully. The Take Care Clause has been essential in constitutional interpretation and argument, a specific example being whether the President can exercise removal powers of federal officials. There are numerous examples, from Supreme Court cases to presidential instances, where the Take Care Clause has been debated. President George Washington, stated, "It is my duty to see the laws executed. To permit them to be trampled upon with impunity would be repugnant to that duty." Minimally, the clause signifies that the President may neither breach federal law nor order his or her subordinates to do so, for defiance cannot be considered faithful execution. Many believe that the Constitution also bars the suspension and dispensing of law. Hence, the Constitution itself never grants the President authority to authorize private violations of the law, issue individualized dispensations, or nullify laws, suspend their operation. Beyond such, there are several conundrums regarding the clause as well, such as whether the President must forcibly instill law that he or she believes is not constitutional. Recent presidents have argued that unconstitutional laws are not laws to begin with and do not require enforcement. Though some scholarly arguments are made to the point that presidents are required to enforce any and all laws emanating from the legislature, Another issue to be seen is in reference to the president's supposed responsibility to enforce statutes that limit his or her authority in the first place. Some suppose that Congress can insulate execution from presidential control, while others insist that Congress cannot strip away the president's duty. And lastly, current federal laws suppose that enforcers have extreme discretion in fulfilling said enforcement. Resources are limited by natural occurrence, and the president must weigh the pros and cons of scarce resource allocation. What determines faithful execution of the law is the prudence of judgment by the president as he or she decides what financial means are spent where. The majority of Article 2, Section 3 is rather unimportant. One interesting note to make is that the conferring of information to the legislature by the president has become increasingly limited. Another important fact is that the president is increasingly charged with the formation of legislative agendas, speaking as the head of the respective parties and nearly guaranteed support by said political party. Of most contemporary importance is the Take Care Clause. By virtue of his executive powers, the president may execute federal laws and control executive officers who execute those laws. This is modified by the Take Care Clause, which requires faithful execution of laws. The Founding Fathers favored presidential power over legislative execution because it implemented decisive action, which was absent in the Articles of Confederation. A single executive seemed peculiarly well circumstanced to superintend the execution of laws with discernment and decision, with promptitude and uniformity, as Alexander Hamilton put it. Currently, there are several arguments revolving around the Take Care Clause, the first of which regards the removal of federal officers, as mentioned. An unfortunate scenario is the creation by the Supreme Court of independent entities that function as a fourth branch of government. They are initiating a variety of federal laws to investigate and prosecuting alleged violations. The legislature has prevented the removal of top officers of such by imposing for-cause restrictions. Not only does Congress limit presidential power through this means, but it has also implemented other obstacles and statutes to make the president's faithful execution of the law more difficult. Another argument is the issue of whether the president must enforce laws that he or she deems unconstitutional. At times, the president has argued that a law is unconstitutional and they will ignore such laws. The Take Care Clause, however, prevents the president from refusing to honor, defend, and enforce federal laws. A more deliberate point of view argues that these unconstitutional laws are null from their inception and therefore independent from the clause. The Supreme Court has never outright guaranteed this power to the president, but has left slight hints that this is a presidential liability, and it has historical implications starting with some of the first presidents who refused to enforce specific laws that they thought were unconstitutional. A final issue regarding the Take Care Clause is whether a president may not enforce a statute based on policy. An example is that of the president's ability to forgive federal offenses in the form of a pardon, therefore foregoing the enforcement of certain investigative provisions. Also, because of constraints on resources, the president's discretion is what sees certain areas of enforcement get more funding than others. This gives the president the ability to choose which laws are to be enforced at which time he or she deems important. Since it is such a conundrum for the president to declare constitutional power to not enforce statutes, contemporary presidents typically avoid neglecting provisions in statutes. Many have argued that the discretion exercised by the president is in violation of faithfully executing the laws. Sometimes these issues are vastly convoluted. It was common knowledge during the time of the Founding Fathers that the legislative branch was the most powerful. One important balance enacted was making the legislature bicameral and the executive unitary. It would be redundant to argue that Congress is twice as powerful as the president. However, it can be seen that he or she is in charge of the most powerful branch of government. Article 2, Section 3 has not largely expanded presidential power. It is important to note that presidential power is distinguished primarily today by historical context rather than strict constitutional interpretation. One Supreme Court justice has stated the Constitution does not disclose the measure of actual controls wielded by the modern presidential office. There are numerous instances perpetuating how the president has become the most influential position. Firstly, national power and culture largely revolve around the president, and he or she therefore exercises the ability to determine the sway of politics. The ability of the executive branch to be concentrated in a single entity, which is elected by the people, instills a magnitude of emotions elicited by the people who are the electors. Secondly, presidential power expands exponentially as each succeeding president furthers the historical context of such power by building on what predecessors have done. Thirdly, the federal government has vastly expanded, growing upward to a head at which the president sits. The president's discretion can be felt throughout his growing bureaucracy, that is, the executive branch, and has long-reaching influence. Political agendas can be strived for by vast amounts of resources at the president's disposal. Fourthly, because of the quick decision-making that is possible by a unitary executive, vast responsibility has been placed in the presidential office. Fifthly, resulting from a change in the nature of political intrigue, when the president's party holds a majority, congresspeople are likely to follow suit with the president, as he or she is seen as leading such a political party. Sometimes, even when the opposing political party holds a majority in the legislature, the president is able to claim obstructionism, possibly furthering his political power. Many have disagreed on whether the Take Care Clause should be interpreted to prevent the creation of independent agencies, because protecting the officers in these agencies from removal at will by the president interferes with the latter's ability to execute the laws they see fit. However, in order to maintain a nonpartisan amicability, it can be argued as important to establish such independent agencies. Qualified regard for enabling too much power in the president arises from the question of whether the president must enforce laws that they believe to be unconstitutional. It is particularly delicate interpretational practices that distinguish whether the president must or should comply with such laws. It is impossible to enforce and prosecute for every law in existence, and it is widely up to the president to set discrepancies in funding for certain provisions and statutes, which he or she may prioritize. However, there's a major paradox when it comes to whether a law can be outrightly ignored by the president. Illegitimate usurpations of legislative authority are an existential problem. Article 2, Section 4, the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. In the last section of Article 2, all officers of the United States are described as being removable if convicted in an impeachment trial of treason, bribery, or other high crimes and misdemeanors. Approximately 20 people have been impeached by Congress, and the procedure begins in the House of Representatives, with the conviction and trial being carried out by the Senate. This rare occurrence implicates the constitutional text sparsely. As a result, the point of the impeachment clause was to ensure more checks against transgressions by unfit public officials. It is much more common for officials to resign than to go through an impeachment trial. Early in the nation's history, the Senate decidedly made it so that members of Congress would be expelled by their own chambers, and typically the president has swiftly removed unfit executive officers from their positions. Primarily, the debate revolving around the impeachment clause has been distinguished by the definition given to high crimes and misdemeanors. It has been seen that this phrase does not encompass those officials who are generally unfit or incompetent, but sometimes distinguishing between a damaging official to the public good and one that is simply unfit can be difficult. As an example, in the first impeachment case, the federal judge on trial was consistently seen as unfit and lacking in actual crime. The Senate ruled him guilty as charged, deferring from convicting him of high crimes and misdemeanors. There are numerous questions about what is considered a high crime and or misdemeanor, leading to questions as to what justifies an impeachment trial. It is now accepted, for the most part, that an impeachable offense is constituted as one supported by the majority of the House of Representatives. Excuse me. Therefore, if an impeachment trial is suggested, an impeachable offense must be persuasively argued to be reasonable and justified throughout most of Congress. The impeachment power is a tool that most members of Congress are unwilling to use if it can be avoided, but they have also wanted to preserve it as a tool that is flexible enough to be used in any exceptional circumstance that might arise. The Founding Fathers were desperate to establish the three branches of government and incorporate a series of checks and balances that would improve independence while maintaining public confidence and accountability. Government officials need to be independent enough to be able to act in the public interest, but not so independent as to be able to exercise unchecked power. The Founding Fathers largely depended on voting in electoral processes to maintain accountability, but wisely provided for the possibility of impeachment to be independent enough to be able to act in the public interest, but not so independent as to be able to exercise unchecked power. The Founding Fathers largely depended on voting in electoral processes to maintain accountability, but wisely provided for the possibility of impeachment and removal of public officials. They established this impeachment power in the legislative branch, as it is the most swayed by democratic systems. Purportedly, the impeachment ability has to be somewhat flexible in order to be useful. The founders decidedly prevented the ability of impeachment to be used against those deemed abusive administratively and preferred treason, bribery, other high crimes and misdemeanors as the chosen language, which at the time was still under determination of meaning. Depending on either a narrow or broad reading of impeachable offense, there are implications. A narrower reading would inhibit impeachment for general bad behavior, while a broad reading could perhaps create a partisan weapon to be used against other political officials. Arguably, if treason and bribery were the full extent of reasons for impeachment, then those government officials would possibly only be removed for overt criminal offenses. It is extremely important that these types of offenders be prosecuted. However, it lacks certain definitions of other important impeachable offenses that might damage the public. So far, there have been mostly private offenses that have seen impeachment, such as sexual assault and tax evasion. These offenses call into question the ability of a judge or executive officer to continue to properly perform their duties and maintain the dignity and respect of the office that they hold. The broader the definition of impeachable offenses, the more likely it is to be used as a political weapon. It could possibly disturb the separation of powers through the branches of government if left unhinged to be used as such a weapon. There are three reasons why Congress has not abused its impeachment powers. Firstly, there are precedents that have become measures of impeachable offenses. Secondly, there are important steps that need to be taken during the impeachment process, as outlined in the Constitution. Largely, impeachment efforts do not gain traction because of the partisan nature of Congress. And thirdly, constituents guide the efforts of Congresspeople, and if they do not support impeachment procedures, then such efforts are unlikely to even begin. The Founding Fathers gave the impeachment weapon to Congress, and like other abilities, it has the potential to be abused. The ultimate check on how that power is used is public sentiment. Exercising the impeachment power requires the ability to reach across the political aisle and forge a political consensus. The answer to the question of what could possibly be extremely damaging to Congress that would elicit impeachment and conviction of a public official is treason, bribery, or other high crimes and misdemeanors. Other high crimes and misdemeanors is a section of the phrase most left to interpretation. One Supreme Court Chief Justice described the Constitution is intended to ensure for ages to come and consequently to be adapted to the various crises of human affairs. In relation to impeachment, that provides that the constitutional text does not prescribe every instance of behavior that is impeachable. If it did so, then criminal behavior might go unpunished as a result of the specificity of impeachable offenses. The House of Representatives and the Senate are thus left to indulge in the specificity of such an impeachable offense and to give them definition. There is a limitation, however, on how far the House of Representatives can go in regard to impeachment. There is no reason to believe that impeachment can be brought upon an individual without regard. Pursuant to the Constitution, the Founding Fathers formulated treason, bribery, or other high crimes and misdemeanors specifically for its limitation on reasons for impeachment and to disallow impeachment for any case at all. This leads to the protection of the separation of powers. I got like 3 minutes to finish these last 6 paragraphs. The Founding Fathers identified the ability of impeachment to be possibly damaging to the separation of powers based upon the idea that the power to remove is the power to control. If Congress were able to impeach and remove members of the other branches of government, then they would hence control those branches. One Founding Father helped to prevent the writing of the Constitution. That included the removal of officials for maladministration. This was discarded from the constitutional drafting, and other high crimes and misdemeanors was added. Depending on interpretation, this both protects and enables Congress to impeach only in instances of harming the public good or the extensive compromising of the official's abilities. There is another important constitutional concept to be taken into consideration, that is our commitment to democracy. If Congress were able to remove officers from the other branches, then it would dissent from the public will, as is the case in the removal of presidents. As it stands, the president must be severely damaging to the public in order for his or her removal. This emphasizes just how important it is to limit the power to truly egregious conduct and serious harms to the public. Otherwise, this narrow and speculative potential could undermine our basic commitment to democracy. The dedication of the Constitution to democracy is one instance that perpetuates an intriguing classification of impeachments in the United States. No president or executive officer has been removed from office through impeachment. All of the officials convicted after impeachment and therefore removed were judges. This does not raise as many issues as the impeachment of an elected official as judges are appointed. Impeachment is a powerful tool. It is important to limit such to situations that permit extreme harm to the public good or are existential in relation to an official's ethic in office. If the impeachment tool were not limited, there would be an existential crisis in the separation of powers. Next, we go on to Article 3, the Supreme Court. Pause.